Hear ye, Supreme Court of the State of Idaho is now in session.
Good morning. We're here on Dwayne Kemmer against Bob Newman. Representing and arguing on behalf of the appellant is Matthew Keys. Susan Weeks is appearing at the council table to offer moral support. Brent Featherston is arguing on behalf of the respondent. We sure want to welcome you folks from the frigid north down here to the Banana Belt. Any preliminary matters? Mr. Keys, you may proceed.
May it please the court, Chief Justice Jones, justices and opposing counsel. My name is Daniel Keys and I represent Dwayne Kemmer, Karen Kemmer, and Tim Dolph, the appellants in this matter. We are here today on the Kemmer appeal asking the court to uphold the Idaho Nonprofit Corporation Act and the bylaws of the New Life Missions Church. The general issue before the court today is whether a special meeting held by the respondents complied with the Idaho Nonprofit Corporations Act and the bylaws of the New Life Missions Church. Respondents claim a new board was selected at that special meeting. Kemmer's position is that the actions at that special meeting were void because the meeting was not called by the board and not approved by the senior pastor. Dwayne Kemmer, Karen Kemmer, and Tim Dolph filed an action in the Bonner County District Court asking the court to declare the rights of the parties. Specifically, they asked for the court to declare the rightful and lawful board of the New Life Missions Church. A 4-day bench trial was held. At the end of that trial, many of the facts were undisputed. The New Life Missions Corporation was incorporated in 2001 under the Idaho Nonprofit Corporation Act, with Jack Kirk as the founder and senior pastor. The church had an active congregation with Jack Kirk. Ruth Smith testified at trial that in 2005, the church had around 50 active members. Jack Kirk served as senior pastor and president of the church until 2009. James Tepani was appointed as the acting senior pastor after Mr. Kirk resigned. In 2009 and early 2010, it was undisputed that the board of directors for the church was Dwayne Kemmer, Tim Dolph, and Ruth Smith. At a board meeting held March 28, 2010, the board discussed the need of a regular senior pastor. The board discussed and ultimately concluded that it would have individuals preach sermons so the congregation and the board could decide who was the right fit. The board asked Bob Newman to serve as acting pastor for Sunday services and asked Bob Quinn to serve as acting pastor for Thursday night Bible studies. The meeting minutes were clear that the pastors were discussed, but that no ultimate decision was reached on the senior pastor. Those minutes were clear that there was no vote taken by the members to choose a senior pastor. During the time that Newman was delivering Sunday sermons, there was a decline in the attendance at the church. It had dropped from 50 active members to about 15 at the time of trial. As a result of that decreasing attendance, the board informally discussed the direction of the church moving forward, which included discussions of having Ken Ewing, a former founder, director, and pastor of the church, either returning or merging the church with his church. He expressed an interest in that proposal, as did many of the members of the church. However, Bob Newman in particular strongly opposed that direction. His opposition was so strong that he attended a May 2010 board meeting and launched into an hour-long speech dissuading those in attendance to elect Ewing as senior pastor. That meeting never officially convened, and there were never any other director meetings following that time and the relevant special meeting that we're discussing today. During that time, Dwayne Kemmer voiced frustration with the direction of the church and the contention that was occurring. At a later formal meeting, Tim Dolph, speaking for himself personally and not as a representative of the board of directors, expressed his belief that the church would be merging with Ken Ewing's church. However, at the time of trial, at that time there was no official decision made by the board, and at trial Ruth Smith testified to the same, that statement by Dolph did not reflect any decision approved by the board, and that the board had no specific merger plans. On August 1st, 2010, there was a meeting held wherein Bob Newman, Phyllis Miller, Bruce Smith, and Bob Quinn claimed to have been elected as the new board for the church. They claimed the meeting was a special meeting called by the board and approved by the senior pastor. However, neither Dwayne Kemmer nor Tim Dolph were involved in calling that meeting and were not in attendance at that meeting. It's undisputed that Dolph had not resigned from the board. It was disputed at trial whether Dwayne Kemmer ever verbally resigned. However, it was undisputed that he never tendered a written resignation. Following the close of trial, the court concluded that the meeting was valid because Dwayne Kemmer and Tim Dolph had resigned, leaving Bruce Smith as the sole director, and that the meeting was approved by Bob Newman, who at the March meeting had been appointed as senior pastor and satisfied that requirement of the bylaws. On appeal, Kemmer's raised the following two issues. First, whether the district court erred in concluding that Bruce Smith had authority to call a special meeting. And second, whether the district court erred by finding that the board appointed Bob Newman as senior pastor on March 28, 2010. Turning to the first issue, the New Life Missions Church is a nonprofit corporation subject to the Idaho Nonprofit Corporation Act. That act requires a corporation have a board of directors. The act also requires that all corporate powers be exercised by the board or under the board's direction. It requires that the corporation have bylaws. Therefore, the affairs of the New Life Missions Church are governed by both the Idaho Nonprofit Corporation Act and the corporation's bylaws. Idaho has well-established precedent that actions taken in violation of a corporate act or in violation of the corporation's bylaws are void. For instance, in Glahe v. Arnett, 38 Idaho 736, which was a 1924 case, the court held election of new directors and officers at an improperly called stockholders' special meeting was void. Similarly, in Twin Lakes Village Properties Association, 124 Idaho 132, a 1993 case, the court held that amendments made to bylaws in violation of the procedure required by those bylaws are void, and all subsequent actions based on that improper amendment are also void. Therefore, corporate action in violation of the Corporate Act or governing bylaws is void. In this instance, both the Idaho Nonprofit Corporation Act and the bylaws of the church allow the board of directors to call a special meeting. Based on that ability, the trial court found that Ruth Smith properly called the special meeting as the sole member of the board. However, that finding was clearly erroneous because it was not supported by substantial and competent evidence. The undisputed evidence at trial was that in early 2010, the board consisted of Bruce Smith, Dwayne Kemmer, and Tim Dolph. The trial court did not have substantial and competent evidence that Kemmer or Dolph had resigned at that point or had been removed as directors. The Idaho Nonprofit Corporation Act requires a board member to resign by written resignation.
Where in the text of 3369 does it require that the resignation be in writing? It just seems to me that requiring a written resignation could create a situation where a board would be locked up by refusal to participate by directors and refusal to provide a written document.
Justice Jones, to your first question, it says, a director may resign at any time by delivering written notice to the board of directors, its presiding officer, or to the president or secretary. So in the language of the statute, it says that the mechanism to resign is by written notice. And to your second question, Justice Horton, were there a situation where someone refused to give that written resignation, both the Nonprofit Corporation Act and the bylaws have a mechanism wherein that director could be removed.
But if a majority of the directors, as is the case here, refuse to participate, there's no statutory mechanism for the board to take action to remove directors, creating that lockup situation that I'm talking about.
Well, Your Honor, to that question, I think the facts show that there was never a majority at once that refused to act. The facts are clear in the record that there was no missed meetings or inaction. Were that...
I'm looking at the precedential impact of the decision you're asking us to make, and I'm having difficulty seeing where in the language of the statute that it makes the only mechanism by which a director may resign be by delivery of a written document.
Justice Horton, there's also a mechanism within the Idaho Nonprofit Act where directors who are elected a certain way, for instance, by the members, can then be removed by the members in the same manner in which they were elected. So that would be a further mechanism for removal separate and apart from only the majority of the directors. So there are mechanisms built in. And looking to the reason why you would require a written resignation is because it would prevent instances like this where there's disputed oral statements whether or not those were a resignation. If it's truly simply just a dispute, there could be the requirement to get the written resignation, and if there's the refusal, then the removal procedures would be in place to remove that person. And as I stated, there's no evidence that either Kemmer or Dolph tendered a written resignation. Therefore, the special meeting called by Ruth Smith was an action taken in violation of the bylaws and therefore void. The district court's finding that Kemmer resigned because of statements of discontent and frustration with the governance of the church is clearly erroneous because it ignores the statutory requirement of a written resignation. Likewise, there's no substantial or competent evidence that either Kemmer or Dolph absented themselves from the meetings, resulting in their resignations. The facts at trial show that neither of them missed any board meetings held before August 1 and the March 28th meeting, and respondent's brief acknowledges the same at page 1. More importantly, there's no law or statement in the bylaws that missing meetings forfeits a position on the board. Had that been the case, that meetings were missed, actions couldn't be taken, that's when the removal procedures would be able to remedy that situation. A director that's not doing what they need to do, they could be removed. The trial court's finding that missing meetings caused Kemmer and Dolph to resign is also contradicted by Exhibit E, a letter from Newman to Dolph indicating that he was removed as a director due to a conflict of interest. That letter was received after the August 1 special meeting. So it's contradictory evidence there that the self-proclaimed board, after the meeting, said, "We're removing you." So that contradicts what the trial court found, that they had absented themselves and removed themselves before. So if the directors did not lose their position by resignation, the only other option is removal. And that's also controlled by the bylaws and the Nonprofit Corporation Act. And there's no evidence in the record that there was that unanimous vote removing Kemmer and or Dolph. And there's no evidence in the record that there was a special meeting called by the members to remove them in such a manner that they had been placed in the first place. Ignoring the statutory requirement for resignation, respondents claim in their brief the testimony was undisputed, and Mr. and Mrs. Kemmer on several occasions stated they resigned from corporate office. Yet respondents provide no citation to the court for that proposition. As a result of ignoring the controlling statutory requirement for resignation, the trial court's finding of resignation or removal is not based on substantial or competent evidence. Therefore, this court should reverse the trial court's declaration that Newman, Quinn, Miller, and Smith were the duly elected board of directors for the New Life Missions Church. Turning to the second issue, in addition to the bylaw requirement that that special meeting be called by the board of directors, the bylaws also require that the senior pastor approve of that special meeting. The bylaws, Trial Exhibit 30, page 4, section 2, paren 6, say, "The senior pastor shall provide for the supervision of all services of the membership and shall approve of all special meetings, conventions, or revival campaigns." Therefore, even if this court determines that the August 1, 2010 special meeting was properly called by the board, this court must also determine that the meeting was approved by the senior pastor. And the converse of that is that if there is a determination the special meeting was not properly called, this issue is moot. But addressing it briefly, if vacancy occurs in the senior pastor position, the board is supposed to take certain steps to fill that position. Once again, they are governed by the bylaws, and those are the steps they need to take. The bylaws say, on page 4, section 4 of Trial Exhibit 30, there needs to be a vote taken with majority vote required for the final appointment of the new senior pastor. That's at a special meeting called by the members. In the record, there's no substantial or competent evidence in the record that the New Life Mission Church membership ever voted to appoint Bob Newman as the senior pastor. It's undisputed that at that March 28, 2010 meeting, it was a board meeting and not a special meeting of the members. It's undisputed there was never a vote taken at that meeting by the members to appoint Newman. Those meeting minutes are clear that the replacement of the senior pastor was discussed, but there was never a final consensus reached. Those meeting minutes are also clear that Bob Newman was asked if he was interested in the position and that he said he was interested. The only evidence at trial that Newman was appointed as senior pastor is his own self-serving testimony and the testimony of his wife that he was appointed as such. This is not substantial and competent evidence because that testimony alone, in light of the clear meeting minutes and testimony of the other witnesses at trial, is not evidence, which a reasonable trier of fact would accept and rely upon. And that's the standard set forth in Machado v. Ryan, 153 Idaho, 212, which is a 2012 case. Therefore, the district court's finding that Newman was appointed as senior pastor on March 28, 2010 is clearly erroneous. That meeting was invalid, and all actions stemming from it were void. Accordingly, we ask the court to reverse the district court's judgment and remand the case to the district court to enter judgment consistent with the court's opinion that would be the meeting was improperly held, the actions were therefore void, and that a new judgment be issued according to that. If the court has no questions for me at this time,
Clarify something. You indicated that although you believe that the Nonprofit Corporation Act you can only resign your position in writing, you then indicated that the bylaws also cover that, which would be an exception to that statute. But then you also indicated the statute allows for the majority of the members of the board of directors to remove a director. Do you have the cite for that?
I do, Your Honor. To clarify, the Nonprofit Corporation Act does allow for resignation, and the cite to that.
Well, I understand the cite for that. In writing, and your argument is it's in writing only.
Correct.
But then you indicated also that the statute also allows for the board to force one of its members out by majority vote.
So, and to
Or did
clarify,
I mishear you?
to clarify that, the statute allows resignation. The bylaws are silent as to resignation. With respect to removal, the statute also allows removal. And to find that citation.
And the bylaws also add.
And the bylaws also do, Your Honor. And the statutory reference refers to instances in which they're appointed a certain way, for instance, by the members, or appointed by a board member. And that's the same
Is
mechanism.
that
you could
removal
remove.
for cause or removal of any sort?
I believe it's for any sort, Your Honor. And in addition to that, the bylaws say that the directors, by unanimous vote, can remove. And I will find that cite for you. The removal for bylaws is at Trial Exhibit 30, page 3, Section 6.
I understand what the bylaws say.
Okay.
I wondered what the statute indicated.
Your Honor, that can be found at Idaho Code Sections 3-370 and 3-371.
Thank you.
If there are no further questions, I'll
Don't appear to be. Thank you, Mr. Keys. Mr. Featherston?
thank you.
May it please the court, Chief Justice, members of the court, counsel. It is my pleasure to be here today on behalf of the respondents, Bob Newman et al. Mr. Newman was the senior pastor and therefore president. I'm also representing Ruth Smith, Phyllis Miller, and Bob Quinn, who was an associate pastor. All named defendants in this case. It is fair to say, first of all, that we're dealing with a very small church organization, small in terms of numbers. It has a church facility, a piece of property, that deed is in the record, that one might presume is one of the maybe driving forces behind a case such as this making its way to this court, perhaps. I won't stand before you and tell you that these lay folks necessarily followed every detail of the Nonprofit Corporation Act, or that they understood how to dot the i's or cross the t's. I think the record is quite thorough in the fact that this small church started by a gentleman by the name of Jack Kirk was essentially his organization, and he operated it as he felt appropriate. The testimony at trial indicated fairly clearly that when Jack Kirk wanted to do something, it was done whether the board liked it or not. When there was a new director to be appointed, he selected them, and everyone sort of did a perfunctory vote if they voted at all, and that they became board members. Interestingly enough, and I believe not coincidentally, by 2009 or so, Mr. Kirk had appointed the appellants, or some of them, actually two of the appellants, Dwayne Kemmer and Tim Dolph, as board members. And it is at that point we begin to see in the minutes kept by the appellant Karen Kemmer, the secretary at that time, we see that they are pushing to remove Jack Kirk. This becomes somewhat significant as we look at the court's rulings in its memorandum decision, because there is an attempt to subsequently replace Jack Kirk with a gentleman by the name of James Tapani, which then sometime later the board of directors, specifically the appellants, choose to then characterize as being an appointment of Tapani as an acting pastor and not the senior pastor. A very similar pattern is then played out in this case with regard to Bob Newman and his appointment as a senior pastor. So it appears anyway that the appellants, the board of director members that are appellants here, Dwayne Kemmer and Tim Dolph, were in a sense usurping the power of the corporation even prior to Bob Newman's appointment, even prior to my client's election as board members.
I kind of hate to interrupt you for a question that's probably completely irrelevant, but I'm kind of curious as to why these folks are fighting over a dwindling membership. Is there a gold mine underneath the church building or something? What makes it financially feasible to engage in this kind of fight over a membership that appears to be getting a little bit tired of all this? At least if they've gone from 50 to 15, it doesn't seem like the gates of heaven are going to open up or, provide any refuge to anybody.
I wish I could answer that question, but I'm not sure that I can. I alluded in my opening remarks, I alluded to the fact that there is a piece of property owned by the corporation, that perhaps that is what is dictating this. Jumping straight ahead to what is really the crux of the issue, by early 2010, we see that the board, led by the appellants, is attempting to turn over that church structure to another church, and Mr. Ewing, who was a pastor sometime years past in this church. Whether it was because of a fondness for Mr. Ewing as a pastor, whether it was because Mr. Ewing came to them and sought a place to move his congregation to, is unclear, and I don't think I can answer that question. It is, on a personal level, it's perplexing and a little bothersome that we find ourselves here today.
Well, don't let me tie you down on that. Go ahead with your presentation. Okay. It's just something that...
It's a fair question, and one that I've thought myself about a few times in this case. It is important, I think, to phrase what is really being challenged here, and what from our position, what is being raised by the appellants is a challenge to the court's findings of fact. There's a sense when I read appellant's briefing and hear argument today that we have narrowed this down to a very technical argument about what is a resignation of a board member, what is required. Must it be in writing or not statutorily? There's a sense that that is the crux of the challenge. But it is important to remember and to refer back to the court's ruling and findings where the trial court says that that decision to call the special meeting was, on page 9 of the decision, was due to Dolph, Kemmer, and Kemmer's having resigned or absented themselves from New Life Missions. Ruth Smith was then the only remaining board member. And then the court goes on to find Ruth Smith, with the agreement of the senior pastor and church members, chose instead to call a special meeting to allow for a voting process to fill the board vacancies. And the district court is referring to chose instead, as opposed to Ruth Smith simply appointing two replacements for Kemmer and Dolph. And so the findings there that are being challenged are broader findings. The court makes the finding that this was done, the call was made by Ruth Smith as the sole remaining board member.
It's based upon the finding that Dolph had absented himself from meetings.
Correct.
But there were no meetings called in the interim time that he is supposed to have absented himself. Am I misreading the findings that they in fact are saying he absented himself from the church proceedings on Sunday, or was it actual meetings?
It is both, and the court makes the finding earlier in the recitation of facts. Judge Buchanan notes that there is an incident in May where
Finding 15?
I'm sorry.
Finding 15?
I think so.
The May meeting was a disaster?
Yes. And even
Where Ruth Smith absented herself.
one moment. There is another, here it is, finding 18, next page. Soon after the May meeting, Tim Dolph made a statement before the entire congregation at a Thursday night Bible study that the board had decided to close New Life Ministries and turn over its assets to church building and property to Ken Ewing and Church on the Solid Rock. Mr. Dolph seemed upset and angry at the congregation's reaction. He knocked over his chair as he left. He did not return to NLM's services or meetings after this announcement. So by May or early June, Mr. Dolph
Was not attending church.
He's an absentee. He's an absentee for board, for church, for whatever meetings are involved.
Well, did the board have any meetings?
They did not.
So how could he be absent
Absent
from
from-
meetings that never occurred?
Sure, and that's the fair question. I think from March, the last meeting minutes we have of a board meeting, there's a lot of confusion about meeting minutes in this record, I recognize that. But the last meeting minutes we have are March. That is the last time that the board convenes. The board is supposed to be meeting monthly. They know that. They've acknowledged that in prior board meeting minutes. And they, because of this conflict, they become so dysfunctional they are no longer meeting.
Well, is there anything in the bylaws that say if they don't have monthly meetings, all the board members are removed?
Of course not. I don't think there's anything.
Is there
to that
anything in the
degree.
bylaws that said if you don't attend church regularly, you're removed?
There is. If you are not a member any longer, you're no
Well,
longer.
do they have a
welcome to the board.
membership?
I'm sorry.
Do they have a membership?
Well, that is a challenge.
I mean, do you have to sign up and say I'm a member?
No. The testimony at trial was that you attend, and early on, you got the blessing, so to speak, of Jack Kirk, and you were a member.
But also the bylaws called for the membership rolls
Yes, to
to
be
be
kept.
made out, and they never were in this case until post
That's right.
massacre on Sunday or whatever, when Kemmer and Dolph were removed. essentially.
And I think it's important when we talk about this removal as if it was a coup d'etat.
Oh, no, I'm not saying
that-
that. This is a bona fide dispute among good people. I don't have any problem there.
A poor choice of words on my part.
Oh,
But
okay.
to talk about this meeting, the special meeting and the calling of it and the discussion that led up to that, it is important to remember that Plaintiff's Exhibit 25, which is characterized as meeting minutes, not special meeting minutes, not board meeting minutes, but a meeting of members sort of on an informal basis. And in it, it recites that there have been several meetings, July 15th, July 18th, July 21st, discussing various matters. The important part of that is that Dwayne Kemmer, one of the appellants, is present for that. And Exhibit 25 concludes by stating there will be a special meeting Sunday, August 1, for the purpose of voting membership roster, new bylaws, and the board members. And so one of the appellants, at least, was present at these meetings, was aware that there was an issue of concern by late July.
So you're arguing this is a quasi board meeting, or?
I'm not arguing it was necessarily a board meeting, no. I'm arguing that there was certainly knowledge of the need to address the lack of board meetings, even by the appellants as well as respondents who were gathering together also as members of this church, trying to address what they should
Kemmer's
do.
presence at that meeting consistent with the finding of the court that he had orally resigned from the board?
It is, because these are not board meeting minutes. These are membership meeting minutes. And I think Mr. Kemmer
He
indicated.
had, if in fact, what is the importance of Kemmer attending that meeting if in fact, by that time, as the judge had found, he had resigned? What is the importance of that then?
I think the importance of it is it corroborates the court's finding that he had resigned. Why else would he be at a meeting where the minutes conclude with we're going to have a special meeting to elect new board members if you haven't resigned? Why wouldn't Mr. Kemmer have stood up or objected at that informal meeting and said, I'm your board member, you don't need to have this election? Why wouldn't he have appeared at the August 1st meeting and done the same thing? Why wouldn't Mr. Tim Dolph have done the same thing? I think the question, I believe, from Justice Horton in appellant's argument is timely, is appropriate. The argument that's being advanced to the court is you can only take a board member off when they choose to resign in writing.
Or by the bylaws?
Or by the bylaws.
majority of the board members?
And in this case, our bylaws do say that a special meeting can be called by 2/3 of the voting membership. I note that of the people identified in this Exhibit 25 that were present, there are 9. There are, I believe, 12 or 13 that show up on the membership roster that's voted on August 1st. You have a 2/3 of the then existing
To call a
attendees.
special meeting, were they
To
at the
call the-
special meeting?
To call that special meeting. And so going back to my earlier point, this is simply a challenge to the court's findings of fact, which are more inclusive than appellants wish to argue.
Okay.
Those findings of fact are inclusive to the extent that the court, the district court said, this was a call for special meeting, perhaps initiated by Ruth Smith in her belief that she was the sole remaining board member, at least the only one actively trying to be a board member. But it was one that was confirmed by the senior pastor and president of the corporation, Bob Newman. And it was one that was consulted with and agreed upon by the members, and that's reflected in Exhibit 25.
Is the senior pastor a member of the board? The reason I ask is I'm looking at Section 4
Of the bylaws?
of the bylaws, where, with the exception of the senior pastor, members of the board shall serve for a period of 2 years. That would suggest that the senior pastor,
I saw that very thing first time it, I suppose, settled home with me on the plane last night coming down. And it occurred to me that it is a suggestion that the senior pastor is also a board member. I think later in the bylaws, it indicates that officers and directors may serve dual roles and may be both as well. I
But
guess-
just because you're an officer, that doesn't make you automatically a board member, does it?
No, of course, it doesn't automatically make you a board member, but
So you'd have to be properly become a board member and then also be, and then an officer, or, I mean, you could be an officer who then properly became a board member. Not just the fact that you were an officer makes you a board member.
correct. And I think if you look at the filings with the Secretary of State, historically with this corporation, James Tapani, for example, began as a board of director member and then became pastor, senior pastor, he thought, as reflected in the minutes. But as the appellants subsequently chose to recharacterize him as being an acting pastor, much like they did with Bob Newman.
Well, you can have acting pastors, can't you?
Well, you probably, I suppose you could.
I mean, if you have, you know, a congregation or a church where the pastor leaves, it wouldn't be uncommon to have an acting pastor until a new one was selected, the senior pastor.
You can have an acting pastor, but the bylaws indicate that you must have a president, you must have a senior pastor.
Right, but, you know, if the senior pastor resigns, obviously, then you have to go through a process to appoint a replacement. You just don't automatically have a new senior pastor right afterwards.
That may or may not be the case. There may or may not be a lapse of time. with
Oh, yeah,
an
but there
interim
could be a
pastor.
lapse of time. I mean, obviously, if you have to go through a process even to select a senior pastor, after the prior one resigned, there would normally be a lapse of some time, of time.
And I think that may be the case, but in this case, we don't have, and the trial court made her findings that there wasn't some evidence that was competent in her view to support the notion that either Tapani or, well, the issue relevant to the case was Bob Newman, that Bob Newman was not appointed as an acting pastor, that the minutes did not reflect that. And one has to assume, because it was argued at trial and in post-trial briefing, that the trial court took into account the fact that the appellants had attempted to make that same after-the-fact recharacterization with Tapani, and yet the minutes previously drafted didn't reflect that Tapani was, quote, acting pastor. So there's a pattern here, and the appellant's pattern has been to, after the fact, try to recharacterize that appointment process as acting to suit their needs. I think the district court's findings reflect that she took that into account in making her findings against the appellants in the memorandum decision. There's also the fact that in one instance, the appellants have completely contradicted themselves because Ms. Kemmer, who files the Secretary of State filings, files with James Tapani as the president of the corporation in 2009 or early 2010. So the exhibits in the record reflect that they are contradicting their own testimony at trial. Ms. Kemmer prepared and filed with the Secretary of State and named Tapani as president, which corroborates the finding that he was initially appointed as senior pastor. That same pattern repeats itself with Bob Newman, and I believe the trial court found that.
Let me clarify. As I read the findings, finding 12 says, March 28 board meeting, various names were discussed, voted on for pastor, no decision was reached. Finding 22, August 1, 2010 is the first time that the court makes a finding that Bob Newman was made president of NLM, which I suppose is senior pastor. So until August 1 of 2010, we didn't have a senior pastor. After the resignation on February 9 of 2010 of Mr. Tapani. Is that correct?
I don't believe that is correct. I think,
How am I misinterpreting those findings then?
well, I think in between them, those two findings, I think the court makes note of the appellant's argument that,
Well, makes note of an argument, but not a finding.
that Bob Newman was appointed only as an acting pastor. But the court discounts that and states that the minutes don't reflect that that is the case. I'm looking while I'm speaking, so I apologize. Let me see if I
No,
can,
that's fine.
see if I can find that, that particular section of the decision.
The only thing I saw was page 80 of the record, and finding 12, that Bob Newman testified he thought he was asked to be senior pastor and assumed the role from then on. That's a reference to the March 28th meeting.
Okay, beginning at page 85, I believe, section B, where it is headed, the heading reads, Senior Pastor Bob Newman had the authority to approve a special meeting, I think at the top of the next page, the plaintiffs argue that Bob Newman was acting pastor. However, there is no provision in the bylaws for an acting pastor. Moreover, the minutes of the board meeting, which Bob Newman was asked to be pastor, and prior to that, James Tapani, may make no reference to the position being an acting or temporary appointment. So again, we're dealing with findings of the court based on credibility of the witnesses, the testimony of the appellants, and she's discarding that. She's saying this is not credible. You, Karen Kemmer, one of the appellant plaintiffs, drafted these minutes, and if it was meant to be an acting position, why not say so? Not once, but twice with two different senior pastors. I think to sort of, as I see my time winding down, to bring us back, I think this is significant because what we have here in this case is the appellants are attempting to simply second
Well,
guess
as
that-
far as an acting pastor, I mean, if we can quibble over the words, but the bylaws say that the directors may assign one of the associate pastors as a temporary replacement for the senior pastor. Now, whether temporary, I don't see how temporary is any different than acting.
Okay. And so my question would be, if that were the case, why not say so? Why not say so with Mr. Tapani? Why not say so with Mr. Newman? I think the district court's.
Was there a
finding-
roster presented to the board of directors for this replacement senior pastor?
Was there, I'm sorry,
A roster of applicants?
I'm sure there wasn't. I said at the outset, I wasn't going to profess that they were following all of the details of their bylaws.
And was there a vote of the membership to approve?
I don't know that there was.
So it seems like what you're saying is that this small congregation didn't follow the bylaws or the statutes, and so we should just disregard them and just do what the congregation normally did.
I'm not suggesting that. I'm being frank with you that in fact, the small congregation, non-lawyers who do not understand
Well, I assume they
necessarily
can read.
their bylaws. Well, let me
I
point.
mean, I assume, to me, I don't, but I assume it's like a lot of small congregations. Nobody reads the bylaws once they're created as they go along.
And I guess the big question there, yes, that's true, but the big question is there, what are the bylaws? I would point out a detail that may have been lost in the briefing, but counsel and I began this trial 2 years ago with no knowledge that there were adopted bylaws. And midway through the trial, this is reflected in the transcript, Exhibit 30 is literally produced by a spectator in the audience as being the signed.
Oh, my gosh, really?
Yes,
Amazing.
absolutely the truth.
That's amazing.
Is produced as the only signed copy, which is,
Anybody dispute whether or not these were the bylaws?
yes, there were several versions, and you'll find them in the record as exhibits, because as we prepared for this case, we simply, I simply, and I believe counsel as well, marked and
It's dated?
submitted documents, every set of documents that we could find that had the references being bylaws. And they are different versions.
Where are they dated?
None of them are signed.
Well,
Until
but
the-
this is the signed version, right?
That's the copy that was produced at mid-trial, Your Honor.
But for purposes of this decision, we have to rely on plaintiff's 30 as being the bylaws, don't we?
Yes, I think that's absolutely correct. And so, but in the context of of Justice Eisman's question, am I suggesting that they were okay in disregarding the bylaws? I would simply remind everyone that they weren't sure what the bylaws were. In part, this is because the appellants removed corporate records at some point. This is undisputed that Kemmers went to the church at or just before or just after the August 1st meeting, removed all the corporate records, took them to Alan Kirk, which is Jim Kirk, the founder's son, and where they continued to reside at trial, and as far as I know, do today. So confusion did reign in these meetings, and
Is
there
it
were certainly some
asserted
issues.
that these are a forgery, the May 1st ones?
Is it asserted that the
May 1st bylaws are a forgery?
May 1st, is that Exhibit 30 you're referring to?
May 1st, 2001,
I-
one signed by Alan Kirk.
No, I'm not asserting they're a forgery. I'm
And
asserting
is it
that-
asserted that they were later amended according to the process required?
We don't have any record that they were amended in between the time prior to August 1st of 2010.
Okay.
Could you help me with something? In looking at the judge's opinion, it assumes, I think, that there were three members, that it was a three-member board of directors,
Yes.
starting in 2001 and going up through the August 2010 meeting.
Are you asking me, does the judge
Yeah,
assume?
I mean, that's what I get from reading the opinion.
I can't speak, I'm not sure I can answer whether she is saying that there was always only a three-board member
Well, she
board of
says
directors.
initially there were three members of the board.
It seems to be that when you look at the officers, and it says that the senior pastor shall be the president of this corporation and shall act as a chairman of all business meetings of the voting membership and the board of directors. If he's acting as a chairman of the board of directors, that may mean that
He is a member.
he plus three others are the members because the bylaws require four members.
And I think that goes to the comment earlier
Yeah,
about.
so
the-
when he resigned, suddenly there's only three left.
Right. So if that is true, and as my sort of epiphany on the plane last night about that possibility that you would deem Bob Newman a board member, then you now have Mr. Newman and Ms. Smith calling for the special meeting, and in the absence of Kemmer and Dolph, whether it's absence or resignation. I would like to touch on one or 2 points quickly in the minute that I have left. One is we did raise the argument of waiver. Each and every one of the appellants admitted under oath they are no longer members, have not been members of this church. Membership is a prerequisite to the position they seek, the relief they seek in this litigation. It is a prerequisite to board of directors taking that position or as an officer, and they no longer qualify for that. They indicate that they are members of the other church, which was the church attempting to take control of this structure. This is an alternate grounds. I think there's a standing issue as well that we've raised in the briefing. I'm not going to belabor it. Appellants have argued that somehow would require us to have filed a cross appeal. I don't believe that is consistent with Idaho law whatsoever. This is an alternate grounds for the same relief that the court gave in her findings of fact. This is a case about the findings of fact. They are challenging those findings, and that is all they are doing. I would respectfully suggest they are challenging it and simply asking this court to second guess the trial court's decision-making. Second guess her findings of fact, second guess her analysis of the credibility of witnesses in light of the documents and their testimony at different points. This is a case in which under 12-121, this court has previously awarded attorney's fees and costs to respondents when an appellant is doing what this appellant is doing, and we would so ask.
Thank you, Mr. Featherston.
Thank you.
Mr. Clerk, how much time does the appellant have?
Appellant has 14 minutes.
14 minutes. Mr. Keys, you may proceed.
Thank you. I'll try and address some of these issues in a logical manner the best I can. First, just to start off what was last argued, the waiver and standing, we've presented to the court through our reply brief that those are issues that we didn't raise on appeal, and they are the types of issues that would have needed to be raised as either a cross appeal or an additional issue on appeal. The case law is clear that if that doesn't happen pursuant to Idaho Appellate Rule 15, that the court shouldn't consider those arguments, because in fact they are asking the court to modify what the district court found and in its memorandum decision and what the judgment ultimately reads. The argument that these are alternative bases is incorrect. The district court clearly said that based on its prior findings that the meeting was valid, that it wouldn't address those issues because they were moved. That's not an alternative ground. It's far from it. And so procedurally, the court should disregard those arguments. There's substantive reasons also. Those were addressed in the briefing. To the statement that we are simply asking the court to be finders of fact all over again and second guess everything, that has no merit. What we've asked the court to do here today is recognize the governing statute and the governing bylaws, and then to recognize that those were not complied with, and the findings of fact do not satisfy the requirements found within.
Are the appellants, you're admitting the appellants are no longer members of the church?
The testimony at trial was that as of the date of trial, these appellants were no longer attending the church. There was no testimony at trial that as of August 1st, 2010, they were not members of the church. And I think the court would recognize that based on the facts that happened and the disputes after that, the letters saying give property back, don't come back here, in the year subsequent, they didn't go to that church. And quite frankly, very few people did now that they've got such a small membership. People stopped going there. But the point of analysis is, what were these appellants at the time of the special meeting? And the argument is clear that that Dwayne Kemmer and Tim Dolph were members of the board. They were members of the church, and they weren't included when the bylaws required that they were to be included in that special meeting and calling that special meeting.
Let me, excuse me, ask a question that's probably stupid, and I'll say that up front. But, excuse me, what does it really take to be a member? I mean, suppose I go up north and I stop in and I attend a church and say hello to people that come back in a few weeks and attend more. What does it take to be a member? Unless you're an officer or something like that where you get voted in. But maybe it's a person that comes to church once every Christmas, maybe on Easter. Are they a member of the church?
Justice Jones, seeing as how this is a religious corporation, and folks who aren't lawyers, there were some different ideas out there what it took to be a member. The bylaws say that you had to be on the rolls. It's uncontested that those rolls didn't exist at some
Well,
point.
that's what I discovered in looking at it. There aren't any roll, is there?
There were attempts to put them together after the fact. There's also testimony that those who were willing to follow the precepts of the church, attend its meetings, they were members.
But when you take a retirement in the bylaws or the statute, a vote of the membership, is it really does a definite body, or some people can vote that don't go to church 2 or 3 times a year? Are they allowed to vote?
According to the bylaws, members are entitled to vote, and not folks who are there once or twice. That's what the bylaws say. And we're here in front of the court, asking the court to recognize that these are it's a controlling statute, it's controlling bylaws. And we don't just set them aside because they happen to not been followed properly. In past instances, that those members never asked for redress. The way the system works is we were wronged, they were improperly removed or claimed to be removed from the board, and the legal system is here to address that wrong. And what governs is the Corporation Act and the bylaws.
Do the appellants claim to still be members?
Today,
Yeah.
I don't believe so. As far as
Or as of the time of trial, do they claim to still be members?
their response at trial was that they did not claim to be members of the church as it was being run by the respondents. Because at that time, they were the ones in control of the church. And they claimed, we are not members of that church as they are running it.
Well, the church is the New Life Missions, Inc. church.
That's correct.
And so were they saying that they are not members of that church at the time of trial?
They were saying they were not members of that church as it had been usurped by those folks. But the whole purpose of the declaratory judgment was to have the court declare, to look at that stage in time, who was the rightful board, and that would determine what the church was, who it was governed by.
If they win this lawsuit, are they going to be members again?
Absolutely, because they'd be declared to be the board. Dwayne Kemmer, Tim Dolph, and Ruth Smith would be the rightful members of the board. That's what the court was asked to declare. Who at that point in time is the board? Who has those rights? What are the rights and responsibilities of the parties? Going to the absentee argument, there was discussion, and it was in the district court's findings, that Tim Dolph had absented himself from meetings, and so he was no longer director. There's no statutory or bylaw authority for that. And looking at just the logical basis there, had that been the case that missing those meetings, which, by the way, are not required under the bylaws that there's a monthly meeting, that's not a requirement. If it were, and if they had been removed for that reason, Ruth Smith would also have been removed for that reason, because she was not holding board meetings. That time period with no board meetings, there were none. So there'd be no members of the board, and we'd even be in more of a pickle. And I don't know how we would solve that, but we don't have to, because that's not what happened. There's facts in the record that Tim Dolph, just 2 weeks before that special meeting, was at meetings. Mr. Featherson talked about a meeting that was held on July 15th. In fact, that wasn't a meeting, that was a Bible study. Those happen on Thursdays, and he was there at that meeting. It's also noteworthy that Mr. Dolph, I'll leave that. There was talk of the bylaws, whether or not they're controlling. There's no question that those bylaws that are Exhibit 30 are the bylaws. There was mention that they were just found late in the game, and so nobody knew about them. That's not the case. What happened is those bylaws were took for safekeeping by one of the church's members, because during this contention that arose, there was a concern that they'd disappear or be damaged. And so that's who came forward during trial and said, I've got these. They were prior kept in a filing cabinet. They were there. People were using them. Tim Dolph brought those meeting minutes, or those bylaws, in fact, to that July. He brought them to a meeting that's, where is it? For the March 28, 2010 meeting, he brought those bylaws. That's Trial Exhibit M. There's also a transcript reference to page 16, line 9, through page 619, line 12. The courts heard this framed as a usurpation of the corporation by the appellants, that in fact they pushed out Jim Kirk. They tried to posture James Tapani to be the new acting pastor, but that's not supported by the record. Jim Kirk left because he had dementia. Jack Kirk, rather. Also, it was clear by Trial Exhibit M that at the March 28, 2010 meeting, when they were discussing a new senior pastor, James Tapani acknowledged he was not qualified to be the senior pastor. He was never appointed as a senior pastor, and he never tried to be. He said, I'm not qualified for this, as they were considering candidates. That's an important distinction. There was no usurpation. There's never been a challenge to Dwayne Kemmer.
There's a notation in the findings that, I think it was the May meeting, where Bob Quinn, is it, or Ben Quinn?
This is Bob Quinn.
Bob Quinn was brought in with Newman, I believe. Were they the candidates for temporary pastor or senior pastor?
They were definitely two of the candidates. The meeting minutes say that they were being considered, and that's why why Bob Newman was asked to preach on Sundays, and Quinn was asked to preach on Thursdays. They were acting pastors in consideration. As I was saying, there's never been a challenge to Dwayne Kemmer or Tim Dolph being rightfully appointed as board members. There's no usurpation. That came later when the respondents got involved, and Bob Newman wanted the church. There was also argument set forth that the meeting held at Exhibit 25 was somehow a special meeting wherein there was a removal of Dwayne Kemmer and or Tim Dolph. Logically, that doesn't make sense, and that doesn't even comport with the findings of facts that the court made, because the court said that they had absented themselves, they had resigned, but now we've heard Mr. Featherston say that because Dwayne Kemmer was at that meeting, that somehow he was removed at that meeting, but that was also noticed to him as a director that the upcoming special meeting was to occur, and somehow he was then involved in it. And you can't have the cake and eat it too. You can't have it both ways in this instance. Either he was already not a board member there, or he was still a board member. And the facts are clear that he was. Based on the Idaho Nonprofit Corporation Act and the bylaws, which do govern the parties, whether or not they were followed in the past, they govern the parties. We ask the court to reverse the decision of the district court, to remand it, and to issue a decision consistent with what happened, what the facts are, what the conclusions of law should have been. That it was not a valid meeting, that we had a board of directors that was not involved in calling that meeting, and therefore all subsequent action is void as a matter of law. Thank you.
Thank you, Mr. Keys. This matter has been fully submitted, and due course an opinion will issue.
All rise, please. It's good to see you.
Thank you, we're good to see you again.
Always good to see
Good to see you, nice to meet you, good to Brad, thank you for the argument, you did a good job.
Thank you.
Oh, Brad.